is so interesting. A couple of things. I'm just curious to know, as we're talking about lawyers and the obligations of lawyers, are you aware as to whether or not any of them have faced criminal penalties that had over 80 counts in 4 different jurisdictions and somehow was not held pretrial? I know that you talked in your opening about your interpretation of what speedy trial looks like, and it's really only for those that are held pretrial. I violated a gag order, and then you went to the judge, and the judge didn't lock them up.
Well done. Gentlelady yields back. Gentlelady from Texas recognized.
Thank you so much, Mr. Chair. This is so interesting. A couple of things. I'm just curious to know, as we're talking about lawyers and the obligations of lawyers, and whether or not maybe the former president has any idea of what good lawyer obligations look like. I'm just gonna ask, we're not gonna play, we're gonna do Ms. Winebanks. Have you heard of any of these lawyers? I've got Robert Cheeley, Kenneth Chesborough, Jeffrey Clark, Matthew DePerno, John Eastman, Jenna Ellis, Michael Farino, Rudy Giuliani, Julia Halia. I got a long list. Have you heard of any of these people?
I have.
Are you aware as to whether or not any of them have faced criminal penalties?
Yes, and also been disbarred or suspended.
Oh, yeah, okay. So they've had some issues, but these are the hand-picked lawyers for Trump. I'm assuming that y'all have never been Trump lawyers, Mr. Trustee or Mr. Costello.
No, I was for a year.
Oh, you were, and you still have your bar card?
I'm sorry?
You still have your bar card?
Yeah, well,
Well,
unless I get targeted for daring to represent a
listen,
former president.
You have absolutely done a lot better than most that deal with him. So good for you. I also want to make sure that we talk about what two-tier really looks like. And Mr. Trustee, since you've been a prosecutor before, I'm curious to know, have you ever had a criminal defendant that had over 80 counts in 4 different jurisdictions and somehow was not held pretrial? I know that you talked in your opening about your interpretation of what speedy trial looks like, and it's really only for those that are held pretrial. And last time I checked, most of the time those people held pretrial, they don't have anywhere near 80 counts pending against them. But I'm curious to know, in your experience, have you ever had someone that had over 80 counts pending in 4 different jurisdictions and they were not held pretrial? Yes or no?
Well, no specific recall,
Okay, all
but
right.
I could answer
That's all
more if you'll let me.
You told me no, and I understand because I hadn't either. So, in addition to that, there's been a gag order, since we're going to talk about the pending trial that's going on right now. Have you ever had a defendant that violated a gag order and then you went to the judge and the judge didn't lock them up, and they done it at least 10 times? I think it's 10. I'm losing count right now. Have you ever had somebody violate?
In 35 years, I had never seen a defendant gagged.
Okay, not my question. So you've never.
Well, it's
had
hard
it.
to get to the second
So
part if they're never
you've
gagged.
never had it. You're absolutely right. All right. So finally, when it comes down to intimidating witnesses, because maybe you haven't had gag orders, intimidating witnesses, have you ever had a defendant that you were prosecuting and they were intimidating witnesses and they didn't somehow end up in the clank for at least a day or two?
I've had criminal death penalty prosecutions based on witness retaliation. I'm very familiar with gang cases and mafia cases. Most of those defendants were already incarcerated when they would orchestrate some sort of obstruction.
Okay.
If there's provable physical violence-based obstruction, it certainly makes sense that they be incarcerated.
Thank you so much. And, you know, Mr. Hamilton, I don't want you to feel left out of this conversation. So I'm going to make sure I ask you some questions. Let me know if you're having problems answering them, because they really should be yes or no. Let's see, you're the executive director for the America First Legal, correct?
That's correct.
All right, and America First Legal is a member of Project 2025, which is dedicated to creating the playbook for the next conservative administration and what it calls the Project Pillars, correct?
We are proud contributors to Project 2025.
Okay, and are you familiar with Project 2025's mandate for leadership.
In fact, I am.
Okay? And in fact, you wrote some of the sections of this mandate related to the DOJ, correct?
Sure did.
And the mandate outlines policy priorities for the next conservative president. Is that correct?
It does.
You've done a great job. I just want to let you know. All right, so let's walk through some of the provisions of the mandate. It calls for eliminating the Department of Education, eliminating the Department of Commerce, deploying the military for the use of domestic law enforcement against protesters under the Insurrection Act of 1807. It also has the repealing of Schedule F status for thousands of federal employees to allow a president to replace career civil servants with unqualified partisan loyalists. That's probably my favorite of it. It also prohibits the FBI from combating the spread of misinformation and disinformation, like Russia and China, who are actively trying to interfere with American elections. I don't know why or how anybody can support Project 2025. And I know that there was allegedly a joke about dictators and whether or not that's funny, but in the United States of America, dictatorships are never funny, and Project 2025 is giving the playbook for authoritarianism as well as the next dictator to come in. And I know that you are doing your jobs here by making sure that hopefully some juror turns on and finds some viral moment of you spewing more of the nonsense as it relates to the president, but as practicing lawyers or licensed attorneys, I hope that we can all agree that no one gets indicted because someone says so. There takes a grand jury, and the grand jury is comprised of American citizens that sit down and review evidence, and they make the determination. And when and if Trump is convicted, it will be a jury of his peers, and it won't be the President of the United States.
I thought you were going to get to a question somewhere in that 90 seconds for Mr. Hamilton after you went after his 2025. I will point out the Inspector General just released a report that said the FBI retaliated against whistleblowers. One of the reasons we do need some changes, but there was no question there. But Mr. Hamilton, if you want to give it some kind of response, you're more than welcome to do that.
Mr. Chairman, my only response would be to say that there are a great number of policy options that have been provided to any future conservative administration through Project 2025, and it's an attempt to restore the rule of law in this country. And I reject the Huffington Post-style characterizations of the recommendations.
All right. The gentlelady yields back. The
And
gentlelady
Mr. Chair.
from, we'll go to the gentlelady from Wyoming, then the gentleman from Florida.
Mr. Chair, I'd ask
Thank you.
unanimous consent.
Excuse me, this is,
I'll get you as soon as we go after this. Just
Okay.
unanimous consent? Are you
Yes,
gonna-
just unanimous consent to enter the mandate for leadership.
Without objection. Without objection. The
Thank-
gentle-
This video captures Representative Jasmine Crockett methodically dismantling the claim that Donald Trump is a victim of two-tiered justice. She begins by grounding the discussion in lawyers' ethical duties, signaling that this is not about politics or personalities, but about professional standards and the rule of law. Her phrase, "We're not going to play," serves as a warning that speculation and talking points will not survive what follows, setting the tone for a fact-driven, methodical inquiry that forces witnesses to confront uncomfortable truths. She then reads out a long list of attorneys closely associated with Trump: John Eastman, Jenna Ellis, Rudy Giuliani, Kenneth Chesebro, Jeffrey Clark, Michael Flynn, and others, and asks whether they have faced criminal charges, disbarment, or suspension. The answer is yes. Crockett's point is subtle but powerful. These legal issues were not isolated incidents or politically motivated attacks. They arose from repeated ethical violations and unlawful behavior. By listing these names consecutively, she emphasizes a pattern, forcing witnesses and the public to recognize the consistent consequences faced by lawyers who align themselves with Trump's most controversial legal strategies. Turning to Jim Trusty, a former Trump attorney and former prosecutor, Crockett establishes his credentials and confirms that he still holds his bar license. Her dry remark that he has done a lot better than most is both a compliment and a pointed critique, highlighting how frequently Trump's associates encounter professional or legal jeopardy. This moment underscores the central tension of her line of questioning. Proximity to Trump has historically carried risk, yet he continues to select advisors with controversial records. Crockett then challenges the two-tier justice narrative head-on. Drawing on Trustee's prosecutorial experience, she asks whether he has ever encountered a defendant facing more than 80 criminal counts across 4 jurisdictions who was not held pretrial. His answer is no, and Crockett confirms that she has never seen such a case either. She emphasizes that most defendants, even with far fewer charges, are routinely detained before trial. By drawing this contrast, she exposes a discrepancy between the claims of political persecution and the actual pattern of legal enforcement. The discussion deepens as she addresses gag orders and witness intimidation. She asks whether Trustee has ever seen a defendant repeatedly violate a gag order, sometimes more than 10 times, without being jailed. Again, the answer is no. She then asks about witness intimidation, noting that such conduct almost always results in incarceration in ordinary prosecutions. Her line of questioning makes the point that Trump's actions, if committed by a typical defendant, would almost certainly have led to immediate jail time, yet he remains free. Crockett then shifts focus to Project 2025 while questioning Mr. Hamilton of America First Legal. She establishes that he is executive director, that America First Legal is a contributor to the Mandate for Leadership, and that he personally wrote sections related to the Department of Justice. Once this foundation is laid, she outlines specific proposals in Project 2025, including eliminating federal agencies, using the military for domestic law enforcement, replacing career civil servants with partisan loyalists, and restricting the FBI's ability to counter foreign disinformation. Her goal is to highlight how these proposals represent a deliberate strategy to concentrate power, weaken institutional checks, and undermine the rule of law. Crockett frames Project 2025 as a coherent blueprint for authoritarian governance, warning that the proposals threaten democratic norms and civil service protections. She dismisses any attempts to trivialize the plan as jokes or exaggerations, emphasizing that authoritarianism should never be treated lightly in a constitutional democracy. Her questions repeatedly force witnesses to acknowledge the seriousness of the proposals, exposing the potential consequences of implementing such a strategy. Finally, she reinforces a core principle of American justice. Presidents do not indict citizens. Indictments are issued by grand juries, composed of ordinary Americans who evaluate evidence independently. If Trump is convicted, she stresses, it will be by a jury of his peers, not by political rivals. The video resonates because of Crockett's disciplined approach. She relies on prosecutorial experience, institutional knowledge, and clear evidence to systematically dismantle the notion that Trump is unfairly targeted. Her measured, methodical questioning leaves little room for spin, allowing the facts to speak for themselves and presenting a compelling case for accountability and the consistent application of justice.